Next up, we've got Chiz, who is coming to talk to us about sanctions. Chiz is an MA in our litigation department who specialises in financial disputes. And as we've all seen in the recent Standard Chartered case, sanctions are very relevant and can catch companies unawares.
Good morning, and thank you all for coming. I should begin by saying that the focus of this discussion will be on financial sanctions rather than trade embargoes and travel bans. I'm also conscious that some of your businesses and clients will be further up the curve of sanctions preparedness than others, but I do hope that you will find some useful takeaways. You'll all have seen, as Clarissa has just said, in the press in the last 12 to 18 months, what seems to be an uptick in sanctions enforcement activity against financial institutions and major corporates in order to act as a meaningful deterrent or a tool of compulsion against states and state actors. Sanctions have evolved to hit international trade hard, thereby annexing certain corners of our international market. I've set out on this slide just a couple of the more recent examples of enforcement action. And the underlying point here is that in recent years, US and European banks have agreed to settlements with American regulators for sanctions violations in the amount of around $5 billion US. So sanctions are evidently a high-risk area, and this is principally for two reasons. One, that they are policy-driven, and this impacts on the incentives and the motivations to enforce by regulatory authorities. Secondly, foreign policy can change dramatically in a relatively short period of time, which means corporates have to adapt their compliance systems quite frequently in order to keep pace with their obligations. I take, for example, Myanmar, which 3 years ago was a pariah state. Today, the European sanctions regime is all but lifted, excluding an arms embargo. The US sanctions have been eased and foreign investment is pouring in. At the other end of the spectrum, one has Iran. And with increasingly stringent sanctions legislation, the US government is sending a clear message to non-US companies that they face a growing risk of being subjected to sanctions in their own right if they continue to conduct business with Iran and Iranian entities. And penalties for violating sanctions can be crippling for a business. The stated intention of the nimbly named Comprehensive Iran Sanctions Accountability and Divestment Act is to present foreign banks with a stark choice: cease your activities with Iranian blacklisted entities or be denied access to American financial systems. Across the principal sanctions regimes worldwide, there are varying degrees of extraterritorial reach, with the US obviously being the most far-reaching. At EU level, I've picked out one of the Council regulations on Iran here, and you can see there that as a case in point, is said to apply to any legal person, entity or body in respect of any business done in whole or in part within the Union. The more extreme example being CISADA, which requires the President of the United States to impose sanctions upon any person worldwide without restriction determined to have knowingly committed the offences listed below. And knowingly in this context includes actual knowledge or constructive knowledge, i.e. The offender in question knew or ought to have known in all the circumstances giving rise to the violation. Even in England and Wales, criminal liability for conspiracy can in principle also apply in the case of sanctions violations under the 1977 Criminal Law Act in relation to violations that take effect in a country outside England and Wales. Now on this slide, which addresses who should be concerned about sanctions exposure, the simple point to make is that sanctions regulators are not just concerned with banks and financial institutions and agencies concerned with processing payments. Aviation Services International was ostensibly a Dutch aviation company, and they found themselves the subject of a US Commerce Department investigation for procuring what's known as dual-use products, i.e. products that can be used for the manufacture of car parts or aviation parts, but could also be used for the manufacture of nuclear warheads, for example, and for procuring such dual-use products for Iranian clients. And this was an affair that led to a $600 million fine at the feet of ING Bank for payment processing. Similarly, an engineering firm, Mabey & Johnson, has paid around £3 million in penalties relating to sanctions violations under the UN sanctions regime against Iraq. I'll briefly consider the context in which sanctions policies come into play in managing a business. Firstly, it's a systems and controls issue. It's imperative to integrate sanctions monitoring into ordinary compliance processes and legal risk management. This must include all necessary checks for pre-notification or pre-authorization of contracts with the relevant regulator. Secondly, it's a crisis management issue requiring a rapid response should a whistleblower shed light on a potential sanctions violation, a regulator notify you of a sanctions violation, or your ordinary detection processes internally identify a potential violation of sanctions. And in those circumstances, it's absolutely critical that a business considers immediately its legal and regulatory position, including whether to make a voluntary regulatory disclosure, which I'll touch upon again later. I've set out here some proven approaches to sanctions policy implementation, which can include centralizing monitoring of sanctions risk, having a sort of boilerplate set of terms for supply contracts, distributor agreements that bind in third parties to sanctions obligations, thereby netting off your risk. Automated screening protocols can also assist. There are a variety of methods, but ultimately embedding a culture of compliance and vigilance is really the first step on the way to ensuring one is protected from sanctions violations. As I said, it's minimizing sanctions risk. It's incredibly difficult to eliminate the risk entirely, and this really boils down to the relevant stakeholders and advisors fully understanding the nature of a company's operations, products, services, and internal structure. This ensures the risk can be mapped across the business properly and that sanctions compliance is thorough without being unduly restrictive. And I set out here some universal principles beginning with senior management or board level commitment, and would stress that much depends on an effective interface between your compliance and legal function, including external legal advisors when necessary. Now, particularly when a company is operating under multiple sanctions regimes, a risk-based approach to due diligence can be very important, and that will involve identifying which parts of your business or particular product lines pose the most risk. And the final, and perhaps some might say the most critical thing to note, is to know thy regulator. It's essential to manage regulatory relationships that helps you understand when it is necessary to make a pre-notification or pre-authorization of a given contract, to understand when a regulator will be receptive to a voluntary disclosure, bearing in mind that an initial disclosure of this type can be your first and most important advocacy piece when confronted with a possible regulatory investigation. Firms should also be aware that regulators these days tend to benchmark their systems and controls against their peers. So the best practice high watermark is constantly being raised. And finally, please just remember that the principal objectives of any sanctions monitoring regime are prevention and detection. So in the event of a prevention failure, being able to at least demonstrate an effective detection system can mitigate the damage in a regulatory investigation situation. There's a lot more I could cover. There have been a number of important new developments, so please feel free to raise any questions with me later. Thank you.
Thank you, Chiz. Certainly in my practice, I find that we're coming across more and more sanctions issues, including a case where a joint venture was pretty much unable to do any business because one of the partners turned out to be on a sanctioned list. So it does become more and more important, even though it seems as if it's an esoteric, quite specialised area.